my name is Officer Nolan. I'm a member of the New York State University Police here at the University at Albany. I'm sure you recognize me from seeing me around campus, and I'm here today to talk to you about warrantless searches and seizures. A lot of the times when we're dealing with people, they claim, hey, I know my rights, and oftentimes we find that people don't actually know what their rights are. So one of the things Chief Wiley wanted us to do was prepare a quick video for you guys on what your rights actually are under both the United States and New York State Constitution. So the general rule is that basically the New York State Constitution and the federal Constitution require that any search be reasonable. And also there is a presumption that any search without a warrant will be per se unreasonable, meaning that unless one of the searches that we do without a warrant falls into a category that the Supreme Court's already recognized as not requiring a warrant, they are going to presume that it's an unlawful and unreasonable search. These are the general exceptions to the warrant requirement here that the Supreme Court has recognized. There are other exceptions, and each one of these doctrines is a vast doctrine outside the scope of this brief video, but we just wanted to cover a few of these to give you guys a general idea of what we're talking about. The first, the automobile exception. I've prepared these in a way that you're going to encounter them on something like a vehicle stop, which is probably the most frequent encounter people have with police officers. And the automobile exception basically says that as long as police officers have probable cause to believe that there is evidence of a crime inside a motor vehicle, we do not need a warrant to search that motor vehicle. One of the reasons is a person's house is viewed as their castle under the law. There's a much more strict requirement to search somebody's home than there is to search a motor vehicle. There is a lower expectation of privacy, and also there's the risk that evidence inside a motor vehicle is more easily moved and destroyed than it would be inside of a home. We're basically allowed to search the vehicle and the containers inside of the vehicle, and in some cases the occupants. One of those cases would be when the officers detect the odor of marijuana, as you'll see in a video that we've prepared for you later. The odor of marijuana allows us under People v. Chestnut to search the entire vehicle, any containers in the vehicle, and any persons inside the vehicle for evidence of contraband. As I mentioned, the standard is probable cause to believe that there's contraband weapons or evidence of a crime inside that vehicle. And the limitation is basically that if I only have probable cause to believe, say, a weapon is inside that vehicle, I'm not going to find a weapon inside a small purse or something like that. So if the size of the object you have probable cause to believe is larger than the containers you're searching, it's not going to be covered under this exception. The next one is plain view, and this is one that we come into contact with a lot. It's pretty easy to understand. Basically, when a police officer sees something illegal in plain view, they can take it without a warrant. We have to be in a lawful vantage point, meaning if I'm somewhere that I'm allowed to be under the law, that is going to be upheld as a reasonable search. However, if a police officer is somewhere they're not supposed to be, if they're inside a home without a warrant and there's no exception justifying them being inside of that home, then the plain view doctrine is not going to apply. The other requirement is that the nature of the item to be seized is immediately apparent. And what that means is I have to have probable cause to believe whatever I'm seeing is contraband or evidence or something like that. I can't just take a guess that it might be. A common thing that you might run into is marijuana. If I see that out in the open and I can articulate that I know that that is marijuana, that's going to be okay. If you see a weapon, obviously in plain view, that's going to be something a police officer can seize. Also, something they may be able to go after is some of the paraphernalia that comes with drugs. A grinder, for example, while the grinder itself is not illegal, I may be able to articulate that because it's involved in, criminal activity like smoking marijuana, there may be evidence inside that grinder. Some courts have also required that the officer does not intend to find something wherever he is. The court has basically said at the Supreme Court level that this is no longer a requirement. However, New York State's Court of Appeals has not yet ruled on this issue. Consent. Consent basically means what it says. If somebody grants me consent to search their house, their vehicle, or their person, I will be allowed to search that person under the law. However, New York State actually gives you more protection than the federal Constitution. Under federal law, a police officer can ask for your consent at any time. New York State requires that we have a reasonable suspicion before we can even ask for consent. Stop and frisk. We covered this extensively in another video, so I'm not going to go over it again. But basically, it's a limited search for weapons only, and the only time police officers can actually search you for weapons is when they have reasonable suspicion to believe that you are armed or dangerous. It doesn't necessarily mean that they see a weapon on you. It can be a bulge, it can be information that they have received that you might be armed. If the person is acting violent or acting in a manner that's aggressive towards a police officer, we can articulate that that person may be armed and may be dangerous. The Playfield Doctrine, basically, if any of you have taken criminal justice classes, you've probably heard of this. It means that while I'm searching for a weapon on your person, if I feel something that I believe to be contraband, the Supreme Court basically allows police officers to go in and get that evidence if they can articulate that it is, say, a drug. But New York State does not recognize this, and basically the only time I'm allowed to actually go in and grab something off of a person is if I believe that that is a weapon. Search incident to an arrest. This requires first that the arrest is a lawful arrest, and second, that I'm only allowed to search the suspect and areas immediately under their control. This is the grabbable area that I'm sure you have heard of. Basically, anytime a person is taken into custody, the court has recognized that prolonged exposure to a suspect with police officers in close quarters like police cars or in booking rooms authorizes and makes reasonable a search of that person to make sure that they don't have weapons or contraband. Inventory. Basically, this applies whenever we have a written policy requiring officers to conduct an inventory of, say, a motor vehicle. If a person is stopped, found to have a suspended license, and are not able to drive that vehicle, or that vehicle is not in a lawful location, if you have a department policy authorizing you to inventory that vehicle and document any valuables, you can search the vehicle without a warrant. Exigent circumstances. This is the one that I think anyone would find reasonable. If somebody dials 911 and says that there's an emergency at a home and the police are responding, it's our job to go in and protect that person. And this doctrine recognizes that. Basically, police can enter a premises without a warrant to respond to an emergency like what I just described, or to prevent the destruction of evidence. If somebody standing outside had a kilo of cocaine and decided that they were going to run inside, slam the door behind them, we can articulate that there is a danger that that evidence is going to be destroyed, flushed down the toilet, dumped down a sink, something of that nature. But in most cases, this doctrine is used to recognize that police need to be able to go in and help people when there's an emergency. Hot pursuit. Similar to what I just described, basically the courts have said you can't defeat an arrest that we were about to make in public by running inside the home and closing the door. The courts have been very hesitant to apply this to minor motor vehicle traffic violations, things of that nature. However, if somebody commits a felony, if somebody is armed, if somebody is a danger to the public, they run from the police and they go into a home, the police are allowed to chase that person under this doctrine.